updates on new pregnancy and breastfeeding employment laws. And we have with us today Shelley Jackson, who's with Krieg, DeVault, and she is going to share some really important information that you will need to know. Shelley also recently presented at the Indiana Rural Health Association's recent conference, and just really want to welcome Shelley here with us today. So Shelley, please feel free to go ahead and share your presentation and we'll move forward.
Excellent. Thank you so much. Got some audio feedback. Let's see. Can everyone hear me?
Yes. And it sounds like the feedback stopped too.
Are you able to hear me?
Yes.
Shelley, you may have called in and dialed in with your computer, so we'll have we'll have to get your speakers muted, but your microphone unmuted. Go ahead and talk, and let's see how it sounds.
I think I fixed it. Do I sound better now?
Much better, yes.
Oh, very good. Thank you. I appreciate the help, Allie. Always getting the settings right is the first hurdle in making these presentations. Well, I am thrilled to be with you today. My name is Shelley Jackson. I'm a partner at the law firm of Krieg, DeVault, and I also lead our labor and employment practice group. And so today I have an opportunity to talk with you about some new developments in employment law that I think are interesting and then also pretty well suited to the 15-minute lightning round format. I will tell you that the presentation that you received in your materials is a full 45-minute to hour-long presentation. So what you'll see me doing today as I talk is kind of skipping around on some of this. But I thought it was important to send you the materials so that you had it to review, and then I can do an overview that will meet our needs for the presentation. So what you should see right now, I hope, is I'm going to actually put it on here and make sure I've got it shared appropriately. You should see the first page of my presentation, which is titled Legal Update, Pregnant Workers Fairness Act and Providing Urgent Maternal Protections Pump Act. So, and you're going to kind of see me look off to the side. I'm going to try to set this up so that is not the case and see if I can get it so that I can be looking at you rather than off to the side. My screen setup has me looking a little bit off to the side here. So let's see if I can figure that out really quickly. And
we can see your slide just fine.
Oh, good. Okay. So I think you're going to have to just see me look off to the side here. I have a screen sitting over here because when I shared my screen, this is the way the screen is showing up with the slide deck. So first things first, this is not legal advice. So I would absolutely encourage you, if you have specific questions for your workplace, feel free to reach out to me and I'm happy to have a conversation about that. That's just a little bit of my bio. And like I said, I spend a lot of time in the labor and employment space, and in particular, I do a lot of work with healthcare entities. So I have my practice straddles both sides of both labor and employment and healthcare. So I really enjoy the opportunity to speak to healthcare, healthcare industry participants. So let's talk about, there's two federal laws. They're new federal laws. They were passed late last year. And I want to talk about both of them, but I'll be very brief, spend about 5 minutes on each of them. The first one is what's called the Pregnant Workers Fairness Act. And the first question that employers sometimes ask is, well, what changed? There were already protections in the workplace. There was a prior federal law called the Pregnancy Discrimination Act, which essentially amended Title VII to include conditions of pregnancy and to prevent discrimination on the basis of pregnancy. And so those things have not changed. There is absolutely still protection from discrimination on the basis of pregnancy. However, there was not previously an accommodation requirement for pregnant workers that was independent of an actual disability. So it would have to be determined using the criteria to establish whether or not a disability existed before a pregnant worker would be able, or a postpartum worker was eligible for accommodation. So the big change that you're going to see, there's a few that we'll run through here, but the big change that you're going to see, first of all, is that proving discrimination now becomes less of a burden within the context of a pregnant or postpartum individual. The other one is there is now going to be a reasonable accommodation requirement. Now, I will tell you, this particular law does not take effect until June 27th, 2023. So you've got a little lead up time to think about the ways that you're providing accommodations to pregnant workers. It also covers private and public sector employers with at least 15 employees. And then other certain employers that are likely not at issue here. If you are a government employer, for example, certain types of government employers would be covered in addition to those with at least 15 employees. So the type and the framework, and this is where you're going to see me zoom through a little bit, the framework for an accommodation from a pregnancy standpoint now will become very similar to that which you already have for qualified individuals with a disability. So you're looking at reasonable accommodation in the workplace. What does that mean? A reasonable accommodation means that there is some accommodation that you can apply to someone's work situation that allows them to perform the essential functions of their job, but doesn't pose an undue hardship on the employer. So if you already are used to thinking in that framework, this is very much the same type of framework. It also requires the same interactive process. And when I say interactive process, what I mean is that obligation of both employers and individuals seeking an accommodation to engage in a back and forth discussion to determine whether or not an accommodation is needed and whether a reasonable accommodation exists in the workplace. It is the similar, there are similar protections. Again, it feels very similar to the types of accommodation protections that exist with respect to the Americans with Disabilities Act. The bottom line is employers need to work in good faith with their employees to determine, number one, is an accommodation needed? And if so, what is a reasonable accommodation? Employees don't have a right to insist on a particular accommodation if multiple accommodations would be effective. By the same token, there's no magic language that has to be used. Although in this case, an employee does have to indicate that an accommodation is needed. There are many pregnant workers who may be in the workplace and never need any accommodation. And that's absolutely sustainable under this framework. This just provides a framework for someone who does believe that they need an accommodation to request that accommodation. I tend to get questions from employers about how to go through that interactive process. And the question sometimes comes up, should we ask our employee to provide medical certification? With respect to medical certification, you apply really a similar standard that you use for a disability-related inquiry into an accommodation. You don't have to require certification. Certainly, you don't always need to request a certification if it's obvious what the accommodation would be and how it relates to the condition of pregnancy. But if there's some uncertainty or you're not positive, you can always request that additional documentation to be provided. So these are some assumptions that should never go into limitations. This is really driven by the pregnant worker, the person who is pregnant in the workplace. So I would really, encourage employers to be responsive to their employees when they are pregnant. And if they're making requests, certainly be responsive to that. But there should be no assumption that someone does or does not need an accommodation. We're talking about essential functions of the job in this slide, which means that those are the things that are key to the job that's being done. So you always want to make sure when you're talking about accommodation and determining whether someone can perform their job, you're looking at the essential functions. If there's something that's not essential to a job, you can take that away, you can modify that pretty easily. But essential functions are the key parts to that job or the key components to that job. So you want to be careful. And one best practice that we always recommend for employers is identify your essential functions before an issue comes up, because it can be really difficult, especially if there was a job description initially when the person was hired, and then they're fabulous and they went on to make the job their own. And then you get down the road and you don't actually have an accurate job description, because then there can be some question about what the essential functions are. I'm going to continue to kind of zoom through this so I can get to the second law and talk about that a little bit. But this talks about some of the different conditions of pregnancy as described by Ask Jan, which is the EEOC sanctioned job accommodation network is what it stands for. And so they give some good information. One question that we have seen come up in the past is, does this new law require accommodation for childcare arrangements? And the answer is no, that is not part of the new law. Here are some examples of accommodations for physical conditions, mental conditions. I would definitely encourage you to take a glance through those if you're having some trouble conceiving as to what those might be. The other thing is, keep an eye on your state and local governments, because some states and some localities have enacted additional protections for pregnant workers. Indiana is not one of them, but if you have any scenario in which you're in multiple different states or some localities, I'm not actually sure whether there are any localities in Indiana. I don't believe there are, but there may be. Let's see, I'm going to get to the second one, and I've just got a few minutes to cover this one. So again, there was this sort of onslaught of federal laws and protections surrounding the pregnancy and breastfeeding experience. And so this is the second one of those, called the Pump for Nursing Mothers Act. And so this actually sits under the Fair Labor Standards Act, which is the act that provides for fair pay, essentially, for work and breaks and things like that. It's really more the work conditions. It's not about discrimination. It's about creating sustainable work conditions. And so it is a condition that is now required in a different way. There was already protection that was required under federal law. So if you're sitting here thinking, what is Shelley talking about? This is not new. We've been doing this. Correct. First of all, a lot of employers have been doing this previously. And in addition, a lot of employers have been exceeding what the standards, the state or federal standards were. So this may be old news to a lot of people. Previously, there was an exemption for employers under 50 employees. I want to make sure, I don't know if it's on this slide or another one, but I did want to clarify, if you were taking advantage of that exemption, I would really encourage you to look back at the policy. And you're not providing those accommodations, I would encourage you to look back, because the standard has changed. And I'll mention that in just a moment. So this law actually went into effect on December 29th, 2022. There is an enforcement deadline that is coming up in 3 days. So we're just on the cusp of an enforcement deadline. That means that you were technically, as an employer, required to comply as of December 29th, but there would be no adverse action taken. You wouldn't be held to account for that until April 28th. So this should be front and center on people's radars. It extends for 1 year past the child's birth, which is the same protection that was previously there. It can be unpaid unless there's some other law that steps in to require that work to be paid, or if the individual is working during that time. So let's say they are expressing breast milk, they're pumping breast milk, and they're still working. They should still, if they are a non-exempt employee, they should still be paid for that time. And then the other thing, there is a cure provision. So if an employer is not compliant, there is this 10-day cure provision that allows the employer to become compliant with what is required. Here's the slide I was thinking of. I wanted to make sure I mentioned this. If you are a small employer under 50 employees, you can claim an exemption, but now there is actually a qualification for the exemption. And I've listed the standards that are used to qualify for an exemption. And these are, I mean, the remedies here are pretty significant. It's $10,000 per violation. And if you think about violations accumulating over time, this can become, a pretty hefty price tag. And then there are also remedies of reinstatement, back and front pay, liquidated damages, and attorney fees. So it's definitely something to pay attention to. And I didn't get a chance to talk too much here, but I would just say, think proactively. Here are some suggestions for that. Avoid statements that can be seen as pejorative or negative toward this. These examples are not theoretical examples. They're actual examples of comments that have sometimes made their way through to the lawyer's side of things. And so keep that in mind. And then it also, there are benefits of being proactive. I've included a couple of links here. I wish you all the best as you continue your convention today. And please reach out if you have questions. Thank you so much to this organization for giving me the chance to talk. And I have appreciated my time with you.
Thank you so much, Shelley. We really appreciate it. And if you have any questions for Shelley, definitely let us know and we will get those to her. And she's also provided her contact information. So we will break now for lunch and we will resume at 12:30.